Good morning, everyone. I am Sara Corradi. I will be your judge today. I think we should wait a few more minutes to see if someone else will join, and just wait to see you in a couple of minutes. Thank you. Good morning, Delvin. I think we can start.
Yes, Sara, good morning.
Good morning. I don't think the other judge will join, so I think we can go ahead. I think the students are all present.
Yes, please start. Yes. Thank you, Sarah. Thank you so much.
Thank you, Delvin.
Good luck, everyone.
Good morning, everyone. As I told you before, I'm Sara Corradi, and I will be your judge today for this preliminary round. So today, just to check, there will be Middlesex University J and as appellant, and Middlesex University A as a respondent. I would just ask to the two universities, to the oralists of the two universities, to briefly introduce themselves and briefly explain me how they pretend, how they are thinking to allocate the time according with the grounds that they will discuss about. Thank you very much.
Good morning, my lordship. I'm Henna. I'm from Middlesex University, Team J. We are, my junior counsel is Miss Ria. Our grounds would be both approx 10 minutes each, and we are open for rebuttal as well.
Good morning, Ms. Sarah. We are Middlesex Team A with... I'm sorry.
Sorry, I say good morning. No, I wanted to discuss, yes, with your colleague before. She will take care of the first ground and the junior appellant will take care of the second ground. they decided to allocate the time in this way.
Are you asking
Hena,
me?
correct?
Yes.
No, Hena.
Yes, my lordship.
Okay. Thank you.
All right then. Good morning once again. Both me and my junior counsel will take 10 minutes each for both of our issues. Grounds, sorry.
Okay. And who will be your junior counsel?
I'm sorry. I'm the senior counsel, Fatima Zahra Isaac, and Roshni Mehreen Syed will be the junior respondent.
Okay. So we can start with Mrs. G at the senior appellant of Middlesex University J. I kindly ask you to try to avoid to read due to the fact this is your secondary round, your second round. So you can try to avoid reading, talk with me, explain with me, and talk slowly in order to explain properly to the judge the issue, the matter. Thank you very much. So I think the stage is now is for Hena, correct?
If I may please the court, my name is Hena Babu and I represent the appellant, Mr. Leif Pale. Before I present my submissions for the benefit of the lordship, would you like to brief the case? Would my lordship like to hear a brief?
Yes, please. Thank you very much. And if you also can, if you also can to explain the facts, what's happening in the case, connected already with the legislation, the jurisprudence, and eventually the doctrine that are in favor to the position of your client. Thank you.
Clevity is a digital platform on which users can create an account and trade in cryptocurrency. The platform's distributed ledger is distributed across various countries, and one such node of the program is based on a server within the DIFC. According to the conditions laid down by the program, the users must maintain at least $50,000 as a cash margin in their account. My lordship, it is to be noted that my party, Mr. Leif Pale, is a user on-off and user.
Sorry, I interrupt you. The line is a bit. I can hear some strange sound. Do you mind to put your volume up, or I don't know? To put
is it okay? Is it okay?
No.
No.
No, I still a little bit, or if you try to put the volume, more volume maybe, or we can ask to our technician if he's listening to us, if he can give you maybe some tips for the microphone.
If I may suggest,
thank you, Fatima. Yeah, because I can't follow properly because it's a bit noisy. There is a noise background and it's quite complicated for me. Thank you.
Is it okay now?
Yeah, much better. Much better.
Okay.
Thank you, Anna.
Should I begin from the beginning?
Yeah, if you don't mind. Thank you very much.
Okay, sure. If I may please the court, my name is Hena Babu and I represent the appellant, Mr. Leif Pale. Before I present my submission for the benefit of the lordship, I may brief the case. Clevity is a digital platform on which users can create an account and trade in cryptocurrency. The cryptocurrency is known as YAPL. The platform's distributed ledger is distributed across various countries, and one such node is based on the server within the DIFC. According to the conditions laid down by the program, The users must maintain at least US dollars 50,000 as a cash margin in their accounts. My lordship, it is to be brought to notice that my appellant, my party, Mr. Late Payne, is a user on the Clevity platform along with the respondent, Ms. Razrani. The appellant's program is called Beta, whereas the respondent's name is Alpha. According to the facts provided, Mr. Payne's program is programmed in such a way that if there are no users offering to sell the YAPL, which is the cryptocurrency, then Beta will automatically offer YAPL for a sale at a higher price. According to our given timeline, on the 10th of June 2022, there was a routine upgrade. As a result, an error occurred, leading Beta to automatically offer to sell YAPL at its default price, followed by Alpha agreeing to buy because 30 minutes before the upgrade, the parties were the only ones permitted to trade according to terms and conditions of the program. Now, the issue occurred when both the parties concluded the trade automatically without any human intervention, since both the parties were asleep. Subsequently, our respondent, Ms. Razani, issued the proceedings in the DIFC courts. Your Lordship, today I would like to cover two main points. First, Article 5A, Section 1, Subsection B of the Judicial Authority Law, which does not apply in the favor. And second, the DIFC court do not have jurisdiction in this case. My lordship, it is to be brought to notice that the first instance court did err in concluding that the DIFC court has jurisdiction over the claim under Article 5A, Section 1 and subsection B of the Judicial Authority Law. My lordship, we strongly believe that the DIFC court does not have the jurisdiction over the claim. The above legislation of the Judicial Authority Law states that the court of the first instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and actions arising out of or relating to a contract or promise contract, whether partly or wholly concluded, finalized, or performed within the DIFC, or will be performed or is supposed to be performed within the DIFC, pursuant to express or implied terms stipulated in the contract. My lordship, as the facts mentioned, the program has multiple ledger nodes across the globe. Therefore, it also has a ledger node in Dubai, UAE, but not in the DIFC. My lordship, with your permission, may I present to you my first submission?
Sure, please go ahead. Thank you.
With the support of the case law of Alibaba Group Holding Limited and Alibaba Coin Foundation 2018, I would like to make my first submission. My lordship, would you like to hear the brief of the case?
Sure, please. Thank you.
The case involves the Chinese e-commerce giant Alibaba Group Holding Limited issuing proceedings in the US court barring the Dubai-based cryptocurrency firm Alibaba Coin Foundation from using the very popular Alibaba name. The Honorable US Judge Paul Odkin in the Manhattan Federal Court issued a preliminary injunction stating that the Manhattan courts lacked the jurisdiction even after the Chinese e-commerce giant Alibaba produced evidence stating that at least one Alibaba coin investor was a New Yorker or was based in New York. It was held that the transaction occurs in the place where the change in a ledger takes place. According to our case facts, there is a ledger note in the DIFC, but it does not mention that the transaction took place in the jurisdiction of the DIFC. We do not have enough materials and facts supporting the accuracy of the location of the transaction. Since the blockchain involves numerous nodes located in different jurisdictions, it is difficult to determine the exact location and hence can lead to completely different and conflicting legal frameworks. My following submission involves using the case law of Iron Science Limited and Duncan Jones and Persons Unknown, Binance Holding Limited and Paywood Limited 2020. For the benefit of the court and the lordship, I may brief the case. In the above case, the appellants allege that as a part of the fraud, the first respondent induced the applicants to invest about £577,000, equating to today's value of 64 bitcoins into various cryptocurrency investment opportunities. The first respondent had stated that the investment had proved to be a success, but unfortunately, the initial investment sums or profits have since been returned to the applicants. The applicants sought various forms of relief from the court on an urgent ex parte application for which permission to serve out of the jurisdiction and by alternate means was one of the forms. The case law which supported our argument is indeed a significant case, particularly because it was the first ever case in which the court had granted permission to serve a freestanding banker's trust order out of the jurisdiction against cryptocurrency. A similar scenario was also in the case of AA and Persis Unknown, where the court was reluctant to pass the judgment. Therefore, my lordship, we can conclude that the English court proceeded on the basis that the territorial jurisdiction was based on the place where the person who owns the asset is domiciled. In our scenario, neither does Razrani, the respondent, or my party, Mr. Laith Payne, is based in the DIFC. My lordship, the DIFC court does not have jurisdiction over the case according to the law number 10 of 2005, part 5, section 15, subsection 2, which significantly states that where the property is in transit or its location is unknown, the validity of a transfer is governed by the law governing the transfer. In such scenario, according to the case facts, we are neither unable to pinpoint a certain location where the transaction took place, nor conclude that it was within the jurisdiction of the DIFC courts. As above mentioned, it is a property. Whether the cryptocurrency is a property was mentioned in the case law of Ruskia and Cryptopia Limited 2020, which states that cryptocurrencies are also a form of property which are capable of being held as a trust. My lordship, with that, I conclude my arguments and I would like to request you to find in favor of my client, Mr. Laith Payne. Unless the court requires my further assistance, these are my submissions.
Thank you very much, Hannah. I have a quick question for you. I would like to know, due to the fact that according with your submission, the IFC court does not have jurisdiction, where do you think that could be instead the jurisdiction?
According to my previous...
for being the right jurisdiction in this case, and why, and under which principle of law? Thank you.
According to my mentioned case, I would like to mention the case name again, the Iron Science Limited and Duncan Jones, which clearly stated that the asset, the owner of the asset. So in this case, in our scenario, Miss Razrani is based in Dubai, but not in the DIFC. And my party, if I had to talk about my party, and I will always favor my party. So my party, Mr. Laith Payne, is based in the Sultanate of Oman. So I would find it would be easier for Mr. Laith Payne or Ms. Razrani to take the proceedings to the Sultanate of Oman, which might be in favor of my party.
Okay, fair enough. I understand the interest of your client, but under which principle of law, under which did you, during your study, during the preparation of the ground, did you find any judgments that support this choice? Because you have, of course, you have to look after the interest of your client, but this has to be supported by a rule, by an article of a legislation, or by jurisprudence, for example. Do you find some jurisprudence in this sense that support this choice? And
the Iron Science Limited case. The Iron Science Limited case. Because the judgment clearly had, because it was in the English court, it clearly said that it was based on the territorial jurisdiction, was based on the place where the person who owns the asset is domiciled.
Perfect. Thank you very much. Did you find any other judgments in this sense during your research, or this is the only case that you found?
There was another case, but it was A and persons unknown, but the judgment was not in favor. And the Iron Science Limited case came after it. So A and persons unknown preceded it. So the latest case comes in favor of my party.
Okay, so always not on the side. Always better not to mention the case that are not in your favor. When you are in front of the judge, it's better if you say to the judge, if you propose the judge the case that are in your favor. Yes. Okay, for me it's fine. If you don't have anything else to add, we can move to the senior respondent for Middlesex University, Team A. Thank you.
Shall I present my case, Your Honor?
Sure. Fatima, correct?
Yes.
Just give me one
please,
second.
Your Honor, I am Fatima Zahra Isaac, and I appear in this matter on behalf of the respondent, Ms. Razwani, together with my learned friend, Roshni Mehreen Sayed, and the appellant is represented by Middlesex team. Before we begin, we find that the court must be notified that our oral submissions will contain two cases that have not been addressed in the submitted court bundle of the respondent. We ask that Your Honor excuses the same. The facts of our case, for your convenience, has already been stated by the appellant. That being said, I will now make my submissions. The first ground to be discussed pertains to jurisdiction of the case. Most transnational online contracts are generally expected to have a choice of forum clause. However, the judge did not err in concluding that in the absence of such a clause, the node of clevity being in the DIFC is sufficient to qualify that DIFC has jurisdiction. Our first submission, Your Honor, is that cryptocurrency is recognized as property. This is established in AA and Persons Unknown and others reported in the 4th volume of the Weekly Law Reports of 2020 on page 35. Would you like to hear the facts of the case, Your Honor?
Yes, please. Thank you.
So in brief, in this case, a hacker infiltrated a Canadian insurance company's security system and installed malware that encrypted all computer systems and demanded a ransom of...
Do you mind to repeat exactly the details of the case, the citation of the case, please?
AA and Persons Unknown and others. I shall continue then. So the hacker infiltrated a Canadian insurance company's security system and installed a malware that encrypted all computer systems and demanded a ransom of $1 million, 200,000 in Bitcoin to receive the decryption key. The object of the hearing pertained to proprietary injunction against the defendant, but the core of the case is whether Bitcoin or cryptocurrency is property. Mr. Justice Bryan, in this case, recognized that Bitcoin and other cryptocurrencies, though intangible and unable to be enforced by action, are recognized as property. Therefore, cryptocurrencies are a kind of property symbolically delivered with the help of a node's function to record transaction and keep track of distributed ledgers. Symbolic delivery is established in Springer Ellipsis, reported in volume number 209 of the Illinois Supreme Court reports on page 261. With the conclusion of the first submission, we submit, Your Honor, that cryptocurrency is property. And using an analogy of law, it is our objective in the second submission to compare it with sale of goods by auction so that we may establish jurisdiction. To begin with, I submit that the grounds for the forum non-convenience test established in Spiliada Maritime Corporation and Cansulex Limited, reported in the 3rd volume of the Weekly Law Reports of 1986 on page 460, are satisfied. In it, Lord Gough quotes Lord Keith when he stated that a natural forum is one which the action had the most real and substantial connection with. Furthermore, he mentions the additional conditions such as the law governing the transaction, whether parties reside or carry on the business. But the condition most substantial to our case is the jurisdiction being transferred to the better available forum who is more appropriate for the trial of the action. It is a fact, Your Honor, that the law in Oman, though it recognizes crypto trading as legal, it does not have any regulatory frameworks governing the same. This is declared by the National Center of Financial Information of the Royal Oman Police and the Central Bank of Oman. So the appellant's submission that the jurisdiction be transferred to Oman would not be, I guess, would not be, I'm sorry, I lost the word for it, would not be right, because Oman is clearly not the most appropriate forum for shifting the case onto. The Dubai Financial Service Authority, on the other hand, is one of the only locations in the world that has introduced a crypto regulatory framework, along with the fact that Ms. Razi is the buyer in this transaction as per the conditions established in Spiliada. The DEC court is the most appropriate and immediately available forum to adjudicate the disputed trade. It may be argued that the transaction occurred in Dubai and not the DIFC, which is an independent jurisdiction from the UAE. However, Article 5, Section A, subsection 1B of the Judicial Authority Law transfers jurisdiction to the Digital Economy Court for crypto-related disputes. Your Honor, our last submission would like to strike comparisons with auctions and crypto trading. Auctions, as defined in Pitchfork Ranch Company and Bartiel Ranch, reported in volume number 615 of the West Pacific Reports on page 541, is a public sale of property to the highest bidder by one licensed and authorized to do so, and the goal is to obtain the best financial return for the seller by free and fair competition among bidders. As observed in the case facts, the disputed trade, and in fact all crypto trading that takes place in Clavity, are performed the same way as an auction is. And when it comes to auctions, Your Honor, we may apply the Article 4, Section 1, subsection G of the Rome 1 regulations, which states that the contract for the sale of goods by auction shall be governed by the law of the country where the auction takes place. Therefore, I submit that from the above evidences, the transaction took place in the UAE, since Ms. Razi is the buyer in the disputed trade, and the UAE allows the DEC to govern the case as established previously. That would be the end of my submissions. Thank you, Your Honor.
Thank you very much. No, I don't have question so far. So I will come back to Mrs. Miss Sena, for her rebuttal, if she will be the one who will face the rebuttal right now. Thank you.
My Lordship, we do not have any rebuttal so far.
Okay, thank you very much. So I think that we can now move to the junior counsel for the appellant, which, if I'm not wrong, will face the ground second regarding the merit, the substantial of the contract. So we just move for, we can move to junior counsel for Middlesex University G. Thank you.
Thank you. If it may please the court, my name is Ria Sehajwani and I represent the appellant, Mr. Leith Payne. Your Lordship, today I would like to cover 2 points. Firstly, the reasonable man test was incorrect, and secondly, that the court made an error in judgment. The DIFC Contract Law Article 37(1)(a) states that if any party made the same mistake or was mistaken or caused the mistake or knew or ought to have known about the mistake and leaving the contract was against reasonable commercial standards of fair dealing, then the mistake at the time of the contract was so significant that a reasonable person in the same situation at the party would not have concluded it at all. In this situation, both Mr. Payne and Ms. Rani were asleep when this automatic transaction took place. And Mr. Payne clearly stated that he had not made the same mistake as Ms. Razi or caused her mistake. He wasn't aware of Ms. Rani's mistake, and so there were no grounds to avoid the disputed trade. Hence, the state of mind of the programmer while designing the program should have been taken into account. The Singapore International Commercial Code uses well-established contractual ideas and considers the theory of mistake while discussing automated contracts produced by computer programming and errors in cryptocurrency trading.
Sorry excuse me, sorry if I interrupt you.
Yes.
Can we come back 1 second to the fact? So can you please explain the facts that happen in this cryptocurrency transaction, and you can relate the facts that actually happen, so the real fact, to the doctrine, to the judgment that you are discussing. And if you don't mind to speak a little bit slow, thank you. So it's more clear for me to understand your point in law. Thank you very much.
Okay, no problem. Just the facts of the case. Just give me a minute. I will go to it. Okay, I have the facts of the case ready with me. So in our case, basically what happened is that when the transaction took place, as Henna stated, Miss Rani and Mr. Payne both were asleep. And so in my first submission, when I'm talking about the DIFC contract law, Article 37(1), it states that if the other party made the same mistake or was mistaken or caused the mistake or knew or ought to have known about the mistake and leaving the contract was against reasonable commercial standards of fair dealing. In the facts of the case, it is also stated that Mr. Payne issued an application challenging jurisdiction, and he also stated that he had not known if Miss Rani made a mistake, and he did not make the same mistake as Miss Rani while programming beta. And so he could not have known about Miss Rani's mistake. So therefore, there can be no grounds of disputed trade, as it is also stated in the DIFC contract law, Article 37(1)(a). And also, we need to keep in mind the state of the programmer, which is also stated in the same article. And since they were asleep, we don't know the state of mind when the transaction took place. Plus, we also don't know the state of mind when they were programming beta and alpha. Now, can I continue?
Yes, please. Go ahead. Thank you.
Most welcome. The Singapore International Commercial Code uses well-established contractual ideas and considers the theory of mistake while discussing automated contracts produced by computer programming and errors in cryptocurrency trading. This is seen in the case of Keon Ptd Ltd and B2C2 Ltd 2019. Simon Thorley IJ provides crucial guidance in this case on how to apply the law of mistake in situations where legally binding contracts were carried out by an automated contracting system, which doesn't have any human intervention of any sort. When transactions were carried out by computers acting as program machines, the court had to consider how to answer the question or whether the parties even knew about them. The court had to also decide whether cryptocurrencies were property that could be kept in trust and what sanctions would be appropriate in the event of a cryptocurrency-related contract or trust violation. In our case, one, the party was asleep, and two, they weren't aware that Clevity had been sold at such a rate, and there were transactions taken from both their accounts. The Singapore International Commercial Code uses well-established contractual ideas. In this instance, the issue happened when Mr. Payne and Miss Rani were both asleep, and since it was an automated settlement, it is seen as an error. To summarize, with the support of the above-mentioned authorities, the reasonable man test was incorrect, and the court neglected the programmer's state of mind, as well as it was an error in the programming. And my lordship, with that, I would like to conclude my arguments, and I would like to request you to find this in favor of my client, Mr. Leith Payne. Unless the court requires my further assistance, these are my submissions.
Thank you very much. no, I will now move to the junior counsel for University of Middlesex A team. Thank you.
My name is Roshni Mehreen, and I appear as the junior respondent in this case. My co-counsel, Fatima Zahra, has already established to the court that the presence of clevities node in the DIFC allows a jurisdiction to adjudicate the case. I, if the court will allow it now, present the second ground, namely that the court of first instance did not err in concluding that it was sufficient to satisfy Article 37, Section 1, subsection A of the DIFC contract law. That
thank you. Sorry, excuse me if I interrupt you. Thank you very much. Do you mind to switch on your video?
Oh, I'm so sorry, I didn't realize. Yeah.
Thank you very much. And start again.
Yes.
Thank you.
My name is.
Start from the beginning. Thank you very much.
Thank you. My name is Roshni Mehreen, and I appear as the junior respondent in this case. My co-counsel, Fatima Zahra, has already established to the court that the presence of DIFC's node in the clevities node in the DIFC allows a jurisdiction to adjudicate the case. I, if the court will allow it now, present the second ground, namely that the court of first instance did not err in concluding that it was sufficient to satisfy Article 37, Section 1, subsection A of the DIFC contract law, that a reasonable trader with knowledge of the circumstances surrounding this particular transaction would have concluded that the disputed trade was a result of an error. I now make my first submission. For a contract to be valid, parties must be sufficiently made aware of the terms of the contract. Contract law is clear that a terms that a party is assenting to must be explicitly made aware to the party, and it must be done with reasonable notice. The importance of this was established by Lord Denning in the case of Thornton and Shoe Lane parking reported in the year 1971. Furthermore, the matter of automations were considered and decided upon to be viewed as an extension of the human mind and is considered a true reflection of the owner or the person's intentional purpose. Thus, it could be stated that the assent to any trade by the algorithms, as in this case, the trade and transaction between the appellant's beta and the respondent's alpha, could stand valid. However, as stated in the facts of the case, the glitch in Clevity software during the short period of time that led to the change and shift in essential terms of the trading, which originally enforced a $50,000 cash margin as opposed to the $200,000 cash margin, which was a particularly onerous clause that was not made aware to the appellant or the respondent with reasonable notice. In the case of Interphoto Picture Library Limited and Stiletto Visual Programs, reported in the year 1987, stated that unusual conditions like the one at hand in which users were excluded based on such a high cash margin must reasonably be brought to the party's attention. Thus, with respect to the two...
Do you mind to describe quickly the facts that they are discussing in the judgment?
Okay.
What actually happened and why the judge decided in this way? Thank you.
Yes. Could I have 2 minutes to gather my thoughts?
Excuse me? I didn't.
Could I please have 2 minutes to gather my thoughts?
Sure.
Well, the judges at the first instant court dismissed the appellant's claim based on the fact that they essentially stated that the respondent had successfully demonstrated that the disputed trade and the transaction that happened between and the transfer of cryptocurrency YAPL that happened was void with respect to Article 37 and Section 1 and subsection A of the DIFC contract law. Thus, with respect to the two...
Excuse me, excuse me. 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 Exc
And that's why.
No, sorry, I was referring to the case you were discussing. You were mentioned the jurisprudence you were mentioned before.
Okay.
You were mentioning jurisprudence, yes, regarding the validity of a contract, and if you can just come back to that case and explain the facts that are at the base of that case and why the judge decided like this. If you know
Okay.
if you remember, of course. Thank you.
Well, in the case of Thornton and Shoelace parking,
Exactly. I was referring exactly to that case. Exactly. 1971, correct? Yeah, I was referring to that case, to the case that you mentioned of 1971, correct? Thornton versus Shoelace.
Yes.
Thank you.
Yes. In the case, there was, I'm sorry. In the case, Thornton, the defendant, the appellant received a ticket in which there was a clause that was, and this ticket was handed out by an automatic ticket machine, and there was a clause that was not brought to the to his attention, so he stated that he needed to be sufficiently made aware of the terms and conditions. And since the automated ticket machine was not a person, they could not have, they weren't satisfying the criteria of making the terms and conditions aware to him. However, the court held that automated machines or automations in general are an extension of the human mind and they represent the person's intentions. Therefore, the judge sided with the defendant and stated that he was sufficiently made aware of the terms and conditions.
Thank you. Thank you very much. You can come back to your submission. Thank you.
And with respect to the two cases stated above, it can be reasonably established that the glitch and the subsequent changes in the terms were not made aware to the party, and therefore the contract could not stand valid. Your Honor, I will now proceed to the second submission that a unilateral mistake has occurred. Mr. Payne claims that as per Article 37, Section 1, Subsection A of the DIFC contract law, he did not make a mistake, did not and could not have about the Ms. Rasrani's mistake. A unilateral mistake occurs when only one party is mistaken as to the subject matter and the other party knew or ought to know about it. As mentioned in the case facts, both the claimant and the respondent were unaware of the transaction that took place. Therefore, as per Article 37, Section 1, Subsection A, Mr. Payne is mistaken as to the terms of the contract. However, Mr. Payne's statement that he made no mistake implies that Mr. Payne is confident in his programming for beta, and by declaring so, he implies that he was aware of the mistake caused by the glitch or any potential mistakes that may happen on the software. Thus, under the case of Hartog and Collins, he assumed responsibility to warn Rani of the mistake and not take advantage of the situation at hand. And his failure to do so makes the contract invalid. Thus, with the above submissions, I conclude that the unilateral mistake was made and request the Court of Appeal to dismiss this appeal.
Thank you very much. Can we do the same exercise of before? Could you please explain me quickly which are the facts that are at the base of the conclusion of the judge in Harton versus Collins and Shields regarding the unilateral mistake? What are the requirements for the unilateral mistake? And why they apply, why they are meaningful for our case. I mean, especially the facts at the base of this, what happened. Because it's it's curious because this is a pretty old judgment, a 1939 judgment. So it's very interesting also to see how a judgment of several years ago can still be applied, and legal principles can still be in place today in 2022 with a total different environment, because of course in 1939 the judge couldn't have any idea of the cryptocurrency, on all the contracts that are concluded by cryptocurrency. So it's also very interesting to have a look and to see and to study, to learn how the jurisprudence developed. Thank you.
So a unilateral request, mistake requires one party to be mistaken, in this case, Ms. Razrani. And by the statements that Mr. Payne is making that he did not make a mistake, the other criteria is satisfied, in which other party must have known about the mistake. And the case of Hartog and Collins, in which there were frequent transactions between the defendant and the appellant, in which there were terms and conditions that have already always have agreed to. However, when due to a mistake made by one of the due to the mistake made by a defendant on one of the terms and conditions, and this there was a mistake made by the defendant on one of the terms and conditions, and this was noticed by the claimant. However, he refused to bring it to the attention of the defendant and chose to take advantage of the situation, even though he knew that this was a mistake made by the defendant, and the defendant refused to fulfill the contract. Therefore, the judges stated that he owed a duty to bring this mistake that he so clearly knew to the defendant's attention, so that he could rectify it, rather than taking advantage of it and going through with the contract, or asking the contract to have gone through.
Okay, thank you very much. I don't have any further question. I will now come back to team A for to team G for their rebuttal regarding the second ground. Thank you.
My lord, is it possible for the senior counsel to rebut?
Yeah, sure. Thank you, Anna.
According to the case facts,
sorry, I just kindly ask you to switch on the video if you can.
Can you see me now? Yeah.
Thank you.
So, according to the case facts, it clearly mentions that Ms. Rajdhani, the opposing counsel's party, programmed Alpha to automatically buy a cryptocurrency, which is the Yahoo, at the best possible price available on the Clarity. The case facts also mentions that my party could sell Yahoo on the platform at a price based on the average price for Yahoo. So if there are no users offering to sell Yahoo on Cleverty platform, Beta will automatically offer Yahoo for a sale at a highly inflated price. In this scenario, I do not see a unilateral mistake, because both the parties have been programmed their program in such a way. So they've both programmed their programs in a very different way. It's not a mistake. I do not find a mistake in this.
Your Honor, may I rebut the appellant's rebuttal?
Sure, please, Fatima, go ahead.
I believe there was a misunderstanding when it comes to our submissions on the appellant side. Our claim, our submission is that there were essential terms of trading that all users in Cleverty subscribe to, which clearly states that there is a $50,000 cash margin for people to trade on Cleverty. So essentially, both parties originally only assented to be part of a market where people above $50,000 where people with above $50,000 in their accounts can participate in. But there was a sudden change in this essential terms of trading that was not brought to the attention of Rani, and which once again completely changes the market that she originally assented to. So clearly the terms were changed, and as per the submissions by my junior counsel, cases declare or enforce that any such changes in the terms of the trading must be made aware to the parties, which was not followed through to Ms. Rani.
And Fatima first, and then I ask Hina also. What do you think about the fact that making contract, especially making a business contract, and then in particular in this context, cryptocurrency is a risky activity with risk? What can you say regarding this this characteristic of the crypto? I mean, in general, the business contract, and especially in the cryptocurrency contract. What do you think it could be fit with the legal principles that you know, and with the jurisprudence that you read? There is some judgment, some judges that face, especially in the jurisprudence that you read, that especially faces these issues, and which is the solution that the judge found. And if you agree, or if you have other arguments to put on the table, this is the right moment. Thank you.
May I answer?
Sure, please, Fatima, go ahead. Thank you.
I do agree that there are certain risks of trading, that a mutual risk that all parties that participate in this industry put onto themselves, but that risk only exists in a contract that was fairly and done by consenting parties. Once you get into the contract, any risk that you put on yourself is fair and would be applied. But as you can see from the case facts, the contract was changed without Ms. Rani's awareness. So this risk, so the faulty the transaction that was made cannot be pit with the same thing as it being a mutual risk that they subscribe to. This is a completely different case since the terms were changed.
Thank you very much, Fatima. Now I will make exactly the same question to Ina, or to a representative of a team Middlesex G. Thank you.
My Lordship, it is clear from the case law of Russian Cryptopia Limited 2020 that cryptocurrencies are today held as a property. So in that scenario, when a contract is open for offer, both the parties consent for the risks that pertains the particular trade.
Can I add on to something Hannah said?
Sure. Everyone is very welcome to add something. Thank you.
With regards to the case, Fatima mentioned that the initial margin that was intended was $50,000, whereas the only ones who had a margin of $200,000 were Miss Rani and Mr. Payne. So when Clevity went under a routine upgrade, this is when the error occurred, right? So now this is considered, as per my ground, it is to be considered a mistake, solely because both the parties weren't aware that this had happened. So to add on to it, this is a risk that both the parties take when they come into a contract with regards to cryptocurrency, as most of these are done by computer systems that have no human interaction.
Thank you, Ria. Yeah, this is one of the basic of this case, the fact that there is a kind of lack of consent, kind of lack of agreement. So how we can manage the automatization, the computer activities with the human beings. This is the central part of your case. So if someone wants to add something, this is the right moment, because I don't have more questions for you.
I simply want to reiterate the fact that I do agree wholeheartedly that there is a risk and that it is a situation of luck, but but that's only in a normal crypto trading, or even say if you bring the example of stock markets, it's the same sort of risk that happens. But in our case, the changing of the terms, it completely changed the situation, and it was no longer about the risk of crypto trading, but a simple plain change of terms that was not brought to the notice, or would reasonably brought to the notice of Ms. Rani.
Thank you very much,
Thank
Fatima.
you.
If someone else has something else to add.
No, my lord.
No.
No, my lord.
So I thank you very much, all of you, for your work. And for me, the session is concluded. And hopefully see you later for the next round. Best of luck to all of you for the Moot Court and for your future career in law. Thank you.
Thank you, Your Honor.
Thank you so
I hope you have a
much.
nice day.
Thank you.